Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is November 5th. This is our bi-weekly community conference call. We have not done this in the last 3 or 4 weeks because we were very busy with the adjustment of status filings and the team needed me there. But we are back again in the swing of things. As usual, we will be doing a call every 2 weeks, every other Thursday. And thank you so much for waiting. I had completely forgotten we had a call today because I've gotten so out of the habit. I haven't had a chance to review the questions, so bear with me. We'll review them as we go along. First question, Misbah. I'm a US citizen, want to apply for parents. Younger sister 13 and unmarried. Can I include her in the form? No. No. There is no way to do that. You can apply for her, but it takes 13 years for her to get here. The better way to do that probably is this. You apply for your parents, let them come to the United States, let her apply for a tourist visa and come with them. Once they are here, it may be possible, please talk to a lawyer, don't do it without a lawyer. It may be possible after she's been here for about 3-4 months to discuss the options with a lawyer and see what is the best thing to do. One way to do it would be to apply, your parents apply for her green card and she keeps extending her tourist visa while the green card is pending. There could be several options, but do not come with a preconceived notion of applying for a green card for her. Okay, *5 if you have a follow-up question on this, *5. Press *5 on your phone if you have a follow-up question. Okay, let's go on to the next question. I've not done this for a while. I just want to make sure everything is working. Yes. Okay, next question, Imran Raza. Daughter is a US citizen by birth, 14 years old, living in India with us. She wants to go to USA for studying. She's a minor. As a father, can I apply for a visitor visa? I actually know a mother who came and stayed with a minor daughter all through the high school. And she kept extending her tourist status based upon that. And the government was okay with it. I don't know about the Trump administration, but at least theoretically it is possible. Just tell them the truth. Never ever hide anything from the government. When you go for the consular interview, just make sure you tell them the truth. But you can't come to USA just because your daughter is a US citizen until she turns 21, at which point she can sponsor you. Okay? *5 if you have a follow-up question, *5. Okay, let's go on to question number 4. This is a research associate on an H-1B, University of Florida, 2020. H-1B was approved, worked as a postdoctoral fellow on J-1 earlier. So 5 years for earlier, okay. Planning to visit India in the 3rd week of December, need to get H-1B visa. On Monday, June 22nd, Trump had signed the proclamation. Am I subject to proclamation? I don't remember the details, but send me an email. I think I had posted this. Let me try to remember. Yeah, go to my LinkedIn page. If you just search for Rajiv S. Khanna, Rajiv S. Khanna, and go to my articles, I had drawn an infographic that details exactly who are subject and who are not subject. And by the way, as Biden wins and things move along, these things might just fade. So the only problem is Biden is going to get sworn in if he wins in January. So nothing is going to happen before then. And your trip is in December. I would also ask ahead because there are 2 levels of problems. One, are you subject to the ban? And 2, is the consulate even issuing visas? Because we have clients stuck in Italy right now where they are exempt from the ban, but the consulate is not issuing visas. Okay, *5 if you have a follow-up question, *5. Okay, next question is from Dinesh. I lived in USA for 6+ years. I had an H-1B, then a green card. My son is born in USA, X, has US citizenship by birth, okay. We returned back to India for good in 2005. My son is turning 21. I have another child, Y, who's a minor. My questions. Can my US citizen son sponsor me? Yes, he can. While he's still in India, yes. The only requirement is that, this is the way I see it, I haven't researched it completely. There's no doubt that your son can apply for you while he's still in India. The only additional requirement may be, and like I said, I haven't researched it completely because you have your cousin applying for your affidavit of support. Your son also has to give it. It may be that when you are getting ready to come to USA, maybe a year or so from now, when your green card gets processed, your son should be actively in the process of relocating back to USA. Either he should already be here or he should be in the process of being domiciled in USA. How long will it take before my wife and minor son? Minor son is the same problem that I discussed just a few minutes ago. For somebody who's got a 13-year-old sister, basically you will have to apply for the minor son once you get your green card. That would be much quicker. He can probably come with you on a tourist visa, make full disclosure to the government what you're thinking, and you should be able to work it like that. I have answered this question, the very first question I answered. Do I need professional services? I don't really know. Most family-based cases, I don't see the need for a lawyer. We don't add much value unless you have no time and no access to information. In that case, yes, definitely. Any way to minimize time gap? No, there is no way to minimize. Is it okay they can come to you on some dependent or study visa? There is no way to minimize. Basically, your son can apply for both your wife and you. And once you get your green card, you can apply for your minor son. But he could be here on a student visa in the meantime, your minor son. *5 if you have a follow-up question. *5. Okay. This one is SCOOCOR. The chronology of events is as follows. A MNC, multinational corporation, okay, had applied for green card EB3, though position was eligible for EB2 in 2007. Got an approved I-140. He applied for I-485. I took a transfer back to India with the company. The company converted to consular processing. Good. 2014, I left. They did not cancel my application. The priority date is current for the last 6 months. I checked with the NVC. Application is not yet forwarded. I have a confirmed job offer from another MNC. Can I use the same application? You cannot. No. You cannot use that application to go to another company. They have to restart the process, but they should be able to use your old priority date. They should be. Okay. If I were you, I would withdraw my application, the old application. That way you get to keep your priority date without question. Okay. *5 if you have a follow-up question. *5. Okay, no follow-up question. Let's go on to question number 7. My question is for a derivative beneficiary in regards to receiving H-1B approval while working on EAD when the date is current. Okay. I'm attaching my question. My EB2 date is current. I'm the primary. My wife is secondary. We responded to RFE. Supplement J given. We are both working on EAD. This past April, wife's employer filed for H-1B. Her attorney is saying she must update her I-9 to indicate her eligibility as an H-1B holder. Maybe the attorney doesn't know all the facts. You should let the attorney know. I'm not sure if your wife was maintaining H-4. If she was not maintaining H-4, Currently, she is on I-485, which is adjustment of status pending. From that, you can't convert to an H-1B, and if you did get a conversion, it was a mistake. The only way she could get a conversion or a change of status from H-4 to H-1B is if she were maintaining her H-4. Therefore, there is no question of upgrading to H-1, or why should the lawyer worry? You have an EAD, that's good enough. In fact, this may be document discrimination even. Maybe not. In any case, you should work it out with them, and they should reach out to somebody else who knows immigration law more than they do, in case they are not immigration lawyers. So, excuse me, I don't see how they can convert her to H-1B, but that's a separate issue. Converting on H-1B has no impact on her adjustment, and her EAD will not get deactivated. Only problem is, see, the EAD rules and the H-1B is subordinate. If she uses her EAD, the H-1B goes away, and it can only be revived by going outside USA, getting a visa stamp, and coming back on H-1B. But using an H-1B does not revoke an EAD or does not in any way affect an EAD. Can she continue to renew her EAD? Absolutely. Her adjustment of status will not be impacted at all. Don't worry about that part. So that's fine. *5, if you are here, press *5. Let's talk. Yeah, I don't see any problem here, sir. I think you are worried unnecessarily. Talk to the lawyers, explain to them she may not have proper status, but she has an EAD, so H-1B has to be activated probably by going outside USA and coming back in. Anant says, this is number 8. My L1A petition was recently approved. I am an Indian citizen. EB1C will be filed while I'm still overseas. How prevalent are RFEs for EB1C? As much as L1A, yes. Does the EB1C process become simpler if I have an approved L1A? It can, but not necessarily. What additionally required? You don't have to worry about it. It's pretty much the same paperwork as far as you are concerned, but your employer may have to produce their tax returns and all. And your lawyer is right. They're nearly identical. No significant additional paperwork is required. Correct. Yeah, if your priority dates are current, you can submit both together. How long for the whole process? Too many variables, Anantji. It could be as little as 6 months, 8 months, or it could be as much. Well, actually, no. You are filing EB1C. You can't do premium. So it could be anywhere from a year to 2.5 years, depending upon some variables for the whole process. Okay. *5, if you have a follow-up question, *5. Okay. Number 9, working for a hospital on a CAP exempt H-1B, private firm applied for CAP subject H-1B, got picked up and approved. Can I work for the hospital on CAP exempt H-1B, on private firm on CAP subject H-1B simultaneously by having 2 pay stubs? That's not how it works. What you'll have to do is, because both companies, chances are you have an approval which allows you to work for only one employer at a time. So what you would have to do is, you can do it either way. You will have to file an H-1B concurrent amendment, so to work with both companies at the same time. And I think it would be easier if you do a concurrent for your for-profit employer. But you'll have to do concurrent H-1B, do an H-1B amendment, and then you can work for them simultaneously. *5, if you have a follow-up question. I see I have a follow-up question already. So let's take that. Area code 571. 1 second. Where are you calling from? 571. Where are you calling from? Oh, you are still muted for some reason. Let's just take a look. No, I unmuted you. Okay. For some reason you're not here. Muting you back up again. Going back to the next question, number 10. I got my green card in October 2020 under EB1 from employer A. They had filed my green card. I have a job offer from B. Different job profile. This profile is in line with my EB. Employer A job profile is full-time position for program manager. B is full-time position for an analyst, not in line with EB1. Can I work for both employers? I don't see why not. I think, look, here is the problem with this. How soon can I leave once I get my green card? There is really no clear law on this issue, but I can extrapolate from the legal principles involved. The way it works is, on the date you file your 485, you should have the intention to stay with the employer indefinitely. You should have no plans on leaving. On the date you get your green card approval, you should have a similar intent, technically speaking. But if the intent changes a week later, that's okay. The important thing is, what was your intention when you got your green card? Okay, so you could potentially work 2 jobs and completely quit employer A and still have no problem, depending upon what your intentions were. Okay, *5 if you have a follow-up question. I'm going to go back to area code 571. I guess no, they haven't raised their hand anymore. Okay, I'll put their hand down. 1 second. Okay, now we have a clean slate. Any follow-up question on what I just discussed? *5. Okay, this one is from area code 571. Hi, I just unmuted you. Do you hear me? 571.
Yes.
Okay, 1 second. Where are you calling from?
I'm calling from Virginia.
Yes, sir. Go ahead. What is your question?
So you said the intention. So this looks like a very confusing thing. So let's say after
No,
5
hang
years,
on.
if
Let
I
me
go
stop
back-
you. Let me stop you for a second. Look, intention is a state of mind. It can only be inferred from the circumstances. It can also be inferred or questioned directly from you. So first of all, if let's say you got your green card approval 3 days before you had an interview with IBM and you had already bought your ticket to move, you had rented a truck, you had told movers to come and start taking your stuff over for a move to California from Washington, D.C. or Virginia, that's a sure sign that you had the intention to leave even before the green card was approved. Can they can they take away your green card? I actually think they still cannot take it away because of certain laws in your favor. But that's not something I would like to test, simply because avoiding getting into an argument with the government is the best thing for our clients. We try to do things in a clean way. So intention is a state of mind, but it can be inferred from the circumstances. Second, you can be put under oath and asked questions directly, and you should not lie. So those are the 2 ways I find out about your intention. Go ahead.
Yeah, sir. So I know this is very confusing. So let me put it simply. If had I been your son, what would you suggest me to do?
First of all, I am not married, so I would definitely congratulate myself for having a son out of wedlock. So that would be nice. But if you were a member of my family or my friend, if the job was really something I wanted and it was important to me, I think the risk is relatively small.
So, sir, if I'm continuing employer A, which is in line with EB1, and I'm continuing the other job, which is in line 1, still it doubts my intention because I joined another firm not in line with I-140?
Well, let's look at another thing. Are you EB1 A, B, or C?
C.
B as in boy?
C as in cat.
C as in Charlie. Okay. So,
yeah.
The job is not in line. You're going from being a manager to an analyst. I personally don't think
So
it
I'm
should.
continuing.
Let me ask you this question. Did you interview for this job before you got your green card?
This B?
Yes.
No, after getting my green.
Yeah, I think you're okay, personally. Okay.
So how about I wait for 6 months entirely with A and then I do all these things? So is it like more safer?
Definitely, that's safer for you. Like I said, the trick in any legal work is avoiding argument. I think if you got into an argument, you would win. But if you waited 6 months from approval, although 6 months is not a magic number, I don't think there is any question that you would have a far lesser chance of any problems. Okay.
Oh, so any timeline you say like 1 year or 6 months?
No,
Do you have any timeline?
I think the farther away you get from the approval, 1, 2, 3, 4, 5 months, the more difficult it becomes for government to try to get to you. Okay.
Okay, got it. Thank you, sir.
Good luck. Good luck. Okay, next question. Oh, there is another one. 1 second. Yes, there is another one from area code 570. 1 second. Yeah, 570. Where are you calling from?
Good afternoon, Raji. I'm calling from Pennsylvania.
Yes, sir. How are you?
I'm doing good. How are you?
Can you just get the vote count done quickly? We are so tired of waiting for you guys.
Sure. So my question is kind of follow-up. So say like after filing the green card I-485, right? And then after 180 days of pending application of 485, still at that point, can I use my AC 21 to change the job?
Absolutely.
And if I do that,
absolutely. That's a different situation. Hang on, stop. Definitely, that's a different situation. What he is asking about is after the green card is approved. While the green card is still pending, I-140 is approved, 485 has been pending 180 days. You can change as many jobs as you like, as long as they are same or similar to your green card job.
So will that not be like intentionally I'm changing my job?
No, but there is a law that protects you expressly. That AC-21, you know what it stands for? It is the title of the law that protects you. AC-21 stands for, hang on, AC-21 stands for American Competitiveness in the 21st Century Act, a 2000 law that was enacted just to protect people from changing jobs.
Okay, so once finally I'm getting approval of my green card, so will there be any question? Will be arise?
Not at all. Not at all.
Why?
We have done this hundreds of times, if not thousands. Never a problem. Okay?
Okay, so when I get my interview for the final green card and if I am changed my job, and will the officer will ask whether he will ask why I changed my job? Because your original company has filed and now you are in a different company.
If he asks you that question, you can tell him that is none of your business. Exactly like that. You can say,
Okay,
sir, that is none of your business. My lawyer told me to tell you that.
Okay, all right. Thank you very much.
Because that's the law. The Congress has provided for it. Nobody can question it. Okay?
Got it. Thank you.
You're welcome. Okay. Oh, we have another question, I guess, a follow-up. Area code 201, I can hear you. You have a follow-up question? Go ahead, please.
Hey, Rajiv, my name is Jay, calling from Edison, New Jersey.
Yes, sir.
This is in line with the question what discussing now. So I did the downgrade, EB3 downgrade, right? My original 140 is based on EB2.
No, I got that.
have a 485 file.
I got that. So
Still is that expected, Raju? I mean,
yeah,
is that the same, like after 180 days?
Yeah, there is one change in the fact pattern. Because you are relying upon a downgrade, the law says AC-21 protects you when your I-140 is approved and your 485 has been pending 180 days. Okay? So your EB3 I-140 approval could take a little while. Once it is approved and your 485 has been pending 180 days, you are fully protected by AC-21. But listen to my language. I-140 is approved and 485 has been pending 180 days. What does that mean? That means, let's take an example. We filed your downgrade today. Your I-140 got approved 100 days later. Now 485 has been pending 100 days. You don't have to wait another 180 days from the date of the approval. You only have to wait 80 more days. Okay.
Got it.
I-140 is approved and 485 has been pending 180 days. You are fully protected. Okay.
Got it. Thank you, Rajiv.
You're welcome, sir. Okay, let's go on. Oh, there's another one. Wow, you guys have a lot of questions about this. What's going on, guys? A lot of job offers out there, huh? Area code 832. Where are you calling from? 832.
Hi, Rajiv. I'm calling from Oregon.
Yes, sir. Go ahead.
Yeah, hi, Rajiv. My question is, my company filed 485 in October, but unfortunately, the location is closed. You know, where I used to work in my company, the physical office, they closed. Now I'm working remotely. I mean, within the same city, it's like 1 mile away from my previous office, but I'm working remotely 100%. But when my firm 140 filed, they filed for the location where it was closed right now.
Your case is different. Your case is different. It needs at least a half-hour consultation. But what I would advise is, you already have lawyers, discuss it with them, see what they suggest. But this could be a problem because your case is a little different. Okay? Now, nobody should be able to take away your priority date, even if they want to withdraw your 485 or I-140. But that needs to be discussed with your lawyers. It's not something I can give you an opinion about without looking at your PERM application, looking at your I-140, and understanding the full reason for the company's move, closure, and what they plan to do. Okay? So talk to your lawyers.
Thank you.
Good luck. Yeah, some questions cannot be answered in a simple yes or no manner or a simple solution. Guys, I'm not doing any new questions. I will only be doing follow-up questions. So area code 419, unless you have a question that follows on leaving the job, put your hand down, press *5 again. Okay. Yes, thank you. What we'll do is, once I'm done with the posted questions, I will answer all your questions because I joined in late. That's the least I can do. Okay. So 2 questions from the same guy, I guess. I don't like that. Just restrict to 1 question. Oh, it's the same question twice. It's the same question twice. Okay, I got this. We already helped that. Next question is number 11. I'm with the same employer for past 10 years. I-140 was approved. Priority date April 2012. Let's say my dates become current. I filed I-485, got rejected. What will happen to my I-140? Is it still valid? Okay. It's a very odd situation. This is what I understand of the law, and I haven't looked at this particular area of the law with too much of detailed attention. But this is how I understand it. If your 485 is denied for some technical reason, you forgot to pay the fees, you forgot to respond to the fee, your I-140 is good and healthy. But if 485 is denied for some other reason, and I can't think of why, government thinks, and this is from reading 10 years ago what I remember, government used to think that once the green card is denied, the green card is extinguished. That means everything that was with the green card goes away. I personally don't see how they can create a crazy conclusion like that, and maybe it should be challenged in courts. But this is what I think happens. So if it's a technical denial, no big deal. If it is a denial on the merits, on the substance of the case, it may extinguish your green card. In that way, you will not be able to use the priority date again. Although I have my doubts, I think it's wrong. And I could be wrong. This was a long time ago I looked at this issue. *5 if you have a follow-up question on this. You had another question. Sorry, I didn't see that. Can I use that I-140 to port my priority date? I already answered that question. Can I refile the 485? Yeah, it depends. If it's a technical denial, sure. My employer is planning to file an I-140 amendment, company name, typo change. Yeah, these are usually small, minor amendments. I don't see why it should cause any rejection. But can your old I-140 get rejected? They can always reopen old I-140s. No question about that. Okay, since there's no question, let's go to number 12. Number 12 says, I got my H-1B transfer from A to B. Consular processing instead of extension. So I've got my approval. Previous I-94 expired August of last year. Wow. What are my options? Wow. This is very complicated. I want you to talk to your lawyers, okay? Or you want to set up an appointment with me to go over your case. We can do a consultation for you. But since you already have lawyers, talk with them, because you're now subject to, let's see, previous I-94 expired on August 9th, 2019. So you're actually subject to now a 10-year bar. Okay. This case might end up in court. So this is a serious problem. You can try getting a nunc-pro-tunc, which means retroactive approval. But this is really weird. And if the lawyers did that unknowingly, or this amounts to ineffective assistance of counsel, it looks like to me. And that can be one of the reasons you can get your retroactive reinstatements, nunc-pro-tunc, okay? But talk to somebody. This is a serious problem. Okay. *5 if you have a follow-up question. *5. Okay. Oh, by the way, when you talk with them, also talk about the 212D as in Dr. 3. 212D3 waiver. Okay. Hamid says, I filed a petition, this is number 13, for my adult son, his wife and children, under the family category, over 10 years ago. They approved the case recently, sent it to NVC. The issue is the date of birth of my son I filled out does not match the one on his passport. It is off by about 18 months. You made a guess about his date of birth. You can point that out to the government. Actually, these days, many of the forms, including Form I-485, contain columns where they ask you other dates of birth used. So it is a common problem. How do you amend it? You could contact the NVC and tell them that you need to make a correction, and they'll probably ask you for something in writing. That's the way I would do it. And you should always use the correct date of birth, whatever that is. So it's not like you should be using 3 different dates of birth. All his documents should be on his correct, real date of birth. Okay. *5 if you have a follow-up question. *5. Okay. Number 14. After 485, normal waiting time for EADAP, who knows? Can we travel outside the USA? Only if you have a pre-existing H1, L1, L2 or H4 stamp. Without stamp, don't travel. If you do travel, your advance parole will have to be refiled. Not your 485, but advance parole. *5 if you have a follow-up question. *5. Okay, this is from area code 206. 206, where are you calling from?
From Washington.
From where?
Washington.
Washington. Yes, ma'am. What can I do for you?
Yeah. Okay, so my question is, I lately received an update from USCIS saying that like my I-485 as October 6th, they are ready to schedule my interview, but till today, it's 1 month, I didn't receive the notice. So how long do I expect to receive it, and when will be the interview would possibly happen?
I have no idea, ma'am. What you should do is, many times, because of the COVID-19 situation, they may be skipping interviews. So some cases we have received approvals without the interview. So what you should do is contact their customer service through the 1-800 number. Okay.
What
The
number?
customer service, the 1-800 number on their website. Okay. And
I do call, but
what did they say?
but it just cannot get into a person to talk with.
Okay. The second option you have is to just contact your local congressman's office. Ask them to find out for you. They can find out for you.
Local what office?
Congressman, member of Congress.
Oh, okay.
Yeah,
okay.
they
So
can.
another question.
Yeah. Go ahead.
Okay, so another question is because it's very close to my 2-year marriage. If the interview day before my 2 years marriage, can I request a postpone the interview after 2-year marriage so that I can be granted 10 years green card, but not a
yes, you can. You can request a postponement. Yes.
But what should I do if I request it?
What should you do? Same process. First of all, they haven't even scheduled you, so there's no question. If you get an interview call, you should then call the 1-800 number. Actually, the notice tells you what to do to get a reschedule. Okay? Ma'am, I gotta go take my next call.
Thank you so much.
Good luck. Guys, be respectful. I can't spend a lot of time with everyone. So let's just make sure you keep your questions short and to the point. Let's see. Area code 570. Go ahead, please. 570.
Rajiv, this is the question for the follow-up question 14.
Yeah, EAD advanced parole traveling. Yeah, I got that.
So currently my H1 visa is expired, and when I go to India, I have an extension, H1 extension.
No, don't do that. Don't travel on that. I think you should either wait for the advanced parole or not travel. Well, actually, you should wait for the advanced parole. Okay.
Okay. So even if I get my advance parole approved, and then if I travel and say like I go for my stamping, and in case if anything is rejected, my H1, and I can use my advance parole to come back.
Definitely,
to US.
Definitely, no question about it. Okay.
And if I use my advance parole, in that case, will I lose my H1 status?
If you come back to work for the same employer, you are considered to be still on H1 even though you used advance parole. Okay?
Okay. I'm good.
Good luck, sir.
Okay. And I actually asked first question, and what is the normal processing time for the approval of my
I have no
EAD
idea.
and AAP?
I don't have any data on that, sorry. You can look up USCIS performance data. I have no idea. We still have cases pending.
Okay.
All right. Let's just go on to the next question. This is Shraddha 2020. Wow, that's a long question. Let's see. Number 15. Started working in H1B visa, employer A, November. Petition is valid till 2012. Switched to B. Worked till 2016. Switched to C. Previous employer B received a notice of intent to revoke. This is too complicated, Shraddha. This is not something I can answer without looking at the entire history of the transaction. Of course, revocation can affect all your cases. I-140 should not be affected, but the H1s can all be affected. Okay? So yes, you definitely need a consultation, talk to your lawyers, figure out what needs to be done, whether you need to just step out and come back in. But I-140 does not get affected by the H1. Okay? *5 if you have a follow-up question. Press *5. Yeah, this is too complicated. I can't answer it in simple. Area code 425, where are you calling from? 425.
Hey Rajiv, I'm calling from Seattle.
Yes, ma'am. Go ahead.
Yeah, you said that I-140 won't be affected, right?
No.
But in case the 485 everything's fine during the interview process, will that revocation will have any impact?
Well, depends. If the revocation is because of some technical reason, no issue. But if it is on the grounds of you committed any kind of fraud or misrepresentation, that's a huge problem. If the employer committed some fraud, no problem. Technical reason, no problem. The only time you could have an issue in green card is if this revocation somehow impacted you personally.
Okay, and sorry, on top of the follow-up, right, Rajiv, the revocation is happened because of the in-house and the employer has pleaded guilty for the fraud, but nothing from my side.
Okay.
And when they ask for the withdrawal, they have withdrawn under the automatic revocation. They have nothing mentioned about fraud or anything on the revocation notice. In this case, being now on my H-1B, because I have my H-1B until 2022, will that make me as like illegal?
I don't know. I don't know the answer to that question. I have to look at your transactions. I really don't know what your current status is until I see the entire history of your case. So talk to your lawyers. If you already have lawyers, they know your case. Talk to them. Okay?
Okay.
Good luck.
Sure, Rajiv.
Good
Thank
luck.
you.
You're welcome. Okay. Yeah, some questions are not possible to answer without a paper trail. Let's see. We go on to the question number 16. Daughter is 18 now, and we will be filing for adjustment of status based upon the filing date. As per CSPA, she'll only get 2 months. Well, first of all, remember, CSPA does not protect people who are filing based upon the dates of filing. They only protect if your final action date becomes current. So let's say if I file today, my daughter is turning 21 in 3 months, and in 3 months, the final action date does not become current, she's not protected by CSPA. Filing and I think personally this is a wrong interpretation, but this is how the government interprets it. So even if they let you file your 485, it's not going to protect her. Okay? I have 2 I-140s. One is from the old employer, then the current employer. To the best of my knowledge, the I-140 that you filed with the 485, I could be wrong, but I think the only I-140 that counts is the one that you filed with the 485. Can she change from F1 to H4? I think you should talk to your lawyers about the F1 H4 issue. In my view, I've had many students, aging out students, who went from H4 to F1 even while their 485 was pending, and the government was okay. They were tolerant. Technically, they can deny the F1 because you have immigrant intent. Also, once you file 485, on that 485, she can go to school. And if she has EAD, she can do internships, work, whatever else she wants. So it's really not a big deal. If we choose to use EAD and not go for F1, and if our final action date doesn't become current, what are the options at that time? I think at that time she would have to go outside USA, apply for an F1 visa and come back, or apply for an H1 if she's ready by that time. I can't predict if there'll be a problem for the F1. I know people who've gotten them. If we use AP to return to USA, do we lose H1B? I just discussed that. You are still on H1B if you are coming back to work for the same employer, same job. *5, if you have a follow-up question on this, *5. Okay, let's see. Area code 408, California. Go ahead, please.
Yeah, hi. Thank you, Rajiv, for your service.
My pleasure.
I have a similar situation.
Okay.
My daughter is 19 and she's on H4 right now. Our filing date, we can file our 485. We have still not done that. We are in the process of doing it.
Okay.
But based on these conversations, I think I'm leaning towards not applying for her adjustment of status at this time, instead choosing to go the F1 route. My question is, if we apply for F1 and later, let's say after a year or so, if the final action date, let's say, becomes current, is there any issue, or do we have to wait for
No
certain
issue.
time
No
after
issue.
the F1
No
is
issue.
approved?
You can file for her 485 at that time. No problem.
No problem, right?
Mhm.
Yeah. And then my other question is the change of status for F1, does it warrant a lawyer, or is it a simple form we can fill in?
It should be a simple form. Personally, I don't think you need a lawyer for this. Also, just to add to what we just were discussing, remember she can only file 485 if the dates are current. And she is under 21 CSPA age, which means real age from which time I-140 pending was subtracted. If that comes out to be under 21, she can apply for 485. Okay.
Understood. Yes. Excellent.
Good luck, sir.
All right. Thank you.
You are very welcome. And this is the last posted. No, there are a couple more, I guess. 2 more questions. Then we can take the other questions that are still left over. My daughter is 18, filing for adjustment based upon filing date. I have 2. I already covered this, right? This is, I think, the same question got posted twice. Okay, so the last question, number 17. No, 17. Second last question. This is number 17. Rahul Joshi. Oh, I know Rahul Joshi. EB2 I-140 is approved. Downgrading to EB3 with concurrent filing. You have 2 separate I-140s. Yes, you can file it like that. Or you can file it as an amendment, which I don't recommend. Can I still continue to maintain our current H1B H4? Yes, you can. You can also use it to enter and exit. But remember, if you have an advance parole pending, you will have to refile it if you travel. H1, H4 don't become invalid. They can become inactive if you start using your EAD. But then you can just reactivate them by coming back on H1, H4 visa. Can the same perm be used for EB3? Yes. Yes, it can be. I'm not going to get into the details of it, but we do it all the time. If EB2 priority date happens to move faster, can you go back to EB2? Definitely. Definitely. Interfiling is honored? Yes, it is. Are there any circumstances in which interfiling cannot be done? If the priority date is not current, they will not honor it. Do I need to produce a copy of every single old I-94? At least from the date of last entry. Typically. If you don't have it, you don't have it. You can let them know you don't have it. Do you need the beneficiary's full name on the birth certificate? Usually yes, but in Indian certificates it's often missing. It can be handled. Any name change things or name discrepancies or incompleteness can be addressed by your lawyers. No issues. Star 5 if you have a follow-up question. Star 5. Area code 608. Area code 608, go ahead please.
नमस्ते राजीव जी.
Rahul ji, how are you? Long time. सब ठीक है?
हेलो.
हाँ राहुल जी, मैंने कहा सब ठीक है. बहुत देर से बात हुआ आपसे.
हाँ, आपके ट्विटर भी मैं पढ़ता हूँ. आप काफी क्या बोलते हैं, courageous है, I must say.
There is no courage when there is clarity. जो गधा है वो गधा है, जो घोड़ा है वो घोड़ा है. उसको जो है वही बुलाओ.
हाँ, लेकिन बोलने के लिए फिर भी क्या बोलते हैं ना, जिगर लगता है.
कोई जिगर नहीं. I told you clarity is what you need. बोलिए, how can I help you?
So my follow-up question is about my own question, item number A. So, and sometime back you just mentioned to someone else that if you have just H1 797 but not stamped visa, which is, so you basically are saying you cannot travel until you get
You should
your
not.
advance
उसका
document?
उसका reason पता है क्या है? उसका reason क्या है कि if you travel without a visa, first of all, there is some ambiguity in the language of the policy that doesn't say clearly, are you allowed to, does that involve abandonment of your 485? If you have a pre-existing visa stamp on your H1B, there is no doubt you can travel. Okay. And you can come back. And there is no effect on your 485. But there is an effect on your pending AP. You have to refile that.
Okay.
Okay.
But if you just have 797, because visas expire.
I wouldn't, because number one, there is a gray area. Second, if your visa stamp gets refused, your 485 is gone too.
Okay. So that's okay.
Yeah. Okay.
But then if you get your advance parole, and let's say after that, if you travel, you can still request H1B visa stamp from the consulate, right?
You can, yes.
That's
perfectly okay. You can.
Basically,
yeah.
Like basically take the advance parole, but don't use it. If you want to just
see, look, let me clarify something. Let's say you have an advance parole, you have an H1B approval, you travel to India or whatever your home country is, you apply for an H1B visa stamp, you get the stamp.
India.
Let's say you get the stamp. On coming back, if you show your advance parole, does that impact your stamp? No, your stamp is still good. So you're still on H1B visa. You can use that to travel in and out. If you enter on H1B visa, is your advance parole still valid? Sure. They can both coexist.
Okay.
All right?
Okay.
Good luck.
Okay.
All right.
Okay. Thank you, sir.
You're
nice
welcome.
to talk to you.
You're welcome. Take care. Bye-bye. So this question is for a friend. Green card expired in 2018. Does he need to renew the green card? Can he apply for citizenship? Green card expired in 2018. I have to look at the law. I don't know. If your green card is not yet expired, definitely you can apply for citizenship. You've got to, you see, I don't know about your taxes, but they do look at your tax history. If you did not file because you were not required to file, there is no problem. Because if you don't make any money and you have no taxable income, I don't think you're required to file your taxes. Okay. But I'm not sure about your, can you file on an expired green card? It should be, you can call USCIS customer service and ask them. Many times they give you okay advice, or you can even look at their frequently asked questions, etc. on their website. I don't remember. I don't recall exactly what the law is. And definitely when it's about to expire, you can file, no problem. But if it has already expired, and I think I remember now, the website frequently asked question says, if your green card is still valid for 6 months, you can apply for naturalization without applying for an extension of your green card. But if your green card is about to expire in less than 6 months, you should file for a green card renewal. I think also, or maybe instead and then do naturalization. Something like that. I have a feeling you might have to apply for a green card extension first, or renewal. Okay. But don't know for sure. *5 if you have a follow-up question on this. *5. Okay. Anyone has any question? Press *5. All right. Let's see how many questions we have. 1, 2, 3, 4. We have 4, 5, 6. Wow. Okay, 7. 7. I think they multiply when I count. I won't count anymore. All right. Let's get started with whatever shows up on my 7 questions. Let's start with area code 608. 608, where are you calling from?
मैं राहुल ही बात कर रहा हूँ. I just talked to you.
जी राहुल.
I had one more follow-up question that I had written down and forgot while talking to you. Very sorry for that. So this is still a follow-up question to my question number 17.
Okay.
And this is about the interfiling stuff I had asked in my main question.
Right.
So if you actually use your EAD, when your 485 is still pending, and if you use your EAD to change your employer, does it mean that now you're stuck in, for example, EB3 and you cannot go back? The interfiling is gone away?
I don't see any connection between those two. So my answer is absolutely not. I don't see why you cannot go back to EB2. Okay.
So even if you use your EB3,
yes,
EAD
Rahulji,
and job,
I understand your question. I answered it already. Do you have anything else?
Nope, I think that's it.
Good luck. Yeah, just because you used your EAD does not keep you stuck in EB3. You can go back to EB2 if you want. Good luck. Okay, let's take the next question. Area code 920. 920, where are you calling from?
I'm calling from Blvd, Wisconsin. Rajiv, thank you very much for your support.
My pleasure.
My quick question is regarding the CSPA. Now I have downgraded my EB2 to EB3. So will I able to use that I-140 processing time for my CSPA in case I need for my daughters?
Yes, you should be able to use. You should be, as far as I know, you should be able to use the I-140 time for the I-140 that is attached to your 485. Yes, you should be able to.
Okay, thank you very much.
You're welcome.
Yeah, thank you. I really appreciate it.
You're welcome, sir. Good luck. Okay, let's go on to area code 224. 224, where are you calling from?
From Chicago.
Yes, sir.
Yeah, thank you, thank you, sir, for your
my name is Rajiv, and you can call me Rajiv. Yes, sir.
Yeah, thank you, sir. And see, sir, I got laid off on October 14th.
Acha ji.
By my employer, but my employer filed for I-485 on October 29th.
Okay, ji. Now this is, wait, you got laid off before the 485 or after the 485?
Before the 485.
Okay. And so they filed 485 on October 29th, you said?
Yeah.
And when did you get laid off?
October 14th.
October 14th. So you filed, that's what I asked you. 485 was filed after you got laid off.
Yeah.
That's what I asked you. Okay. All right. What is the next question? Keep going.
So I should find a new job transferring my H1B in 60 days, or if I don't get any H1B transfer company, can I stay with my I-485?
Well, let's begin by answering simple and easy questions. You can stay in the United States as long as your 485 is pending. Okay? You can stay in the USA as long as your 485 is pending. You will be able to work only once your EAD comes, unless you file your next H1 within 60-day grace period. So you can stay as long as you like. 485 is pending. You'll be able to start work only when the EAD comes. That clear?
Yeah.
Okay, now the bigger problem is I'm not at all sure your 485 is properly filed, because this is something you should discuss with your lawyers. I can't answer it in the time that we have. I can tell you what the issue is. You can discuss the details of your case with your lawyers. If you had to come to me, I would have said, why are you filing 485 if you are already laid off? Obviously, this employer doesn't have a permanent job for you. Why are they filing a 485 for you? Why are they giving you a permanent job offer letter? Unless there is a good explanation for that, that 485 itself can come under question. But as long as it is pending, you are not out of status, you are not accruing unlawful presence, but my concern is that the 485 filing may be questionable. Okay.
Yeah.
That's it. Go talk to your lawyers, figure that out. Come back to me in 2 weeks if you have a follow-up question after you've talked to them. Okay?
Yeah, but while filing I-485, my employer gave the employment letter as he's an active employee
I
and
don't
he
care.
will
I
keep
think
giving him continuity.
that sounds like fraud. I would not be very happy with that. Talk to your lawyers. This can be a serious problem if they have given you a letter that is untrue and you have used it. I find this whole situation very odd. So have your lawyers look into it, okay? I gotta go, sir. You can't just keep me there forever.
Okay, thank you.
All right, you're welcome. Yeah, you guys have to be quick about this, guys. Area code 419, where are you calling from? Area code 419. Area code 419. Okay. Area code 408 again. And this is California, I gather. Let's see. California, go ahead, please.
Yeah, hey, thanks, Rajiv. This is a follow-up question to question 16.
Uh-huh.
So as I was saying, let's say I initiate the process of converting my daughter to F1 now.
Okay.
In given current situation, it takes anywhere between 6 to say 8 months, 9 months, whatever, right?
Mm-hmm.
In the meantime, let's say the priority date becomes current. What options do I have? Like, can I file right away? Do I have to wait for the F1 to get approved?
Well,
like, how does it play out?
See, the way it plays out is Section 245K as in kite will allow her to be without status for up to 180 days and still file her 485. When you have an application pending, let's say you are on H4 and you applied for F1, H4 expired, F1 is still pending. Technically, you are not in status. Okay. And let's say...
No, she doesn't have that issue. Her H4 is valid for 2 more years.
Then there is no problem. Then even though the F1 is pending, you can apply for her 485 right away. No issue.
Oh, no issue. Okay. No. So there is no waiting period or approval to come and any of those things.
Nothing.
Okay. And what do you suggest? I mean, if you were to, as a friend, say, should we apply 485 and hope and pray that in 2 years priority date becomes current, or choose a more conservative F1 route and later on if 485, the priority date becomes current,
it's
change to...
difficult for me to make that decision. I think going the F1 route is probably okay. Maybe that's what you can do.
All right.
Okay.
Okay. All right. Thank you. And if you don't mind, I have just another question unrelated to this one. So I'm also filing for a downgrade from EB2 to EB3, like along with the 485 and all that.
Right.
If I do not file the I-140 in a premium, can the time that elapses can be used for adjusting the CSPA age for her?
Yes, I believe so. You can have your lawyers double check. I think that's the way it works. Just remember, if you try to convert back to EB2, then you would lose the advantage of that I-140 time. Okay? Because then you'll be using a different I-140. Okay?
Understood. That is understood. Yeah. And does the EAD tie to I-140 being approved, or once we file, whatever time it takes, it comes?
No.
Okay.
No, it does not. It moves independently. Okay?
Right.
Good luck.
Okay. Thank you so much.
You're welcome. Okay. Let's take the next one. This is area code 203. I think 2303 is Connecticut. 203, are you calling from Connecticut?
Hi Rajiv, this is Ramendra Sahu. I'm calling from Arlington, Virginia.
Oh, okay. Go ahead.
Yeah, Rajiv, my question is, my H1B extension is up for renewal on on the coming Feb.
Okay.
And my spouse's H4 EAD also. I plan to apply for her renewal and my renewal alongside together. And now given the new wage rules which were into effect on October 8th, and the specialty occupation that's also going to be in effect on December 1st week. So I'm just thinking, what could be the impact on the extension process when I apply, given that I have a bachelor's degree in mechanical engineering, which is, so I like the wording for the specialty of now says that you need to have
Ramendraji, this is not an easy
Yes, sir.
discussion. This is a long discussion. Okay.
Okay.
There are two separate sets of issues. One is the change of regulations. The other one is the merits of your case. How well can your case be presented?
Right.
These are two separate issues. The second issue, only your lawyers who have the files can answer. The first part is, until these regulations are either stayed, reversed, or Mr. Joe Biden wins and gets sworn in and says, throw out all this nonsense, we are stuck with them. So we have to follow whatever they ask us to follow. But if they get stayed, which is very likely, because there are 3 different lawsuits pending against the wage regulations, one of them definitely will get a stay. I think the regulations are all topsy-turvy. The H-1B regulations haven't been sued on yet because they haven't come into play yet. Ultimately, they will also get sued on. So right now we are stuck with them. A week from now, I do not know. All right?
Okay.
Good luck.
Understood. So do you recommend me waiting for till January end or early February for filing so that we get to know the status of this lawsuit?
Also a decision your lawyers must help you make. I can't do that. If your case looks doable to me wage-wise and specialty occupation-wise and otherwise, I would file it now. But if there are any gray areas that make me nervous, I would then wait and watch and see what happens until the last moment. Okay?
Got it. Thank you.
You're welcome. Good luck. Okay, and I think we have just one more question. That's the last question of the day. I will not be doing any other questions, folks. This one is from area code 419. 419, where are you calling from?
Hello, sir. Am I audible to you?
Haji, you are.
Sir, before that, I was not unmuted, so that's why I was keep saying, so aapko sunai nahi diya hoga.
Acha, because I did unmute you and I checked. Maybe it can happen, I guess. But tell me, what can I do for you, sir?
Yes, sir. Currently, I'm a student in the University of Toledo. I'm calling from Toledo.
Yes, sir.
I'm graduating in this December 2020. So my question is, since I don't have any past job experience while back in Mumbai, India, so is it safe to go for the consultancy or the third-party contract? That is my first question. And the sub-question is, I'm not at all, thinking to go till the green card, but yeah, I'm expecting to get the H-1B and its extension. So for the OPT and the STEM extension, how many attempts it is for the H-1B, and is it safe to go for the third party or the contract job?
Okay.
Thank you.
So let's begin with parsing your questions one by one. First of all, remember, the first year of OPT is very flexible. The STEM extensions are as inflexible almost as H-1B, but the first year of OPT is very flexible. You can work in-house at a client site, from home, work 20 hours a week, be paid or not be paid, all of that is okay. Okay. When you do a STEM extension, then you are bound by pretty much the same wage rules, etc., very close to it, as H-1B people. And then it becomes a lot more difficult to work from a client site. I don't think you can. Okay? So then, talking about the H-1B chances, depending upon when your OPT extension begins, you could have anywhere from 2 to 3 shots at the H-1B, sorry. Okay. Just to make it clear, because we have to file the application around April. So let's say you get approved, your first year happens to be around April, your STEM start date, your OPT start date happens to be around April, you will definitely have 3 chances because you get 2-year extension. But if it starts in November,
Exactly. Yeah.
you may not have 3 chances. You might have just 2. Okay. Are we good?
Okay. Yeah. So here it is. Like
Yeah. Hang on one
that
second,
I'm
guys. I already told you this was the last question I'm answering. I will not be able to answer any more questions. So please put your hands down. Go ahead, sir. Go ahead.
Yeah. Yes, sir. It is since I told you that I'm graduating in December 2020. So I'm searching a job since August and September, and I feel that okay, there is no chance for the entry level jobs. There's only job for the experienced students or the experienced people. So in the month of January, I'm thinking to go for the consultancy, or you can say the third party payroll. So and they are telling me that they will file my H1B once I get my OPT card, that EAD card, the OPT card.
Right.
I already applied for my OPT. So they are telling me if you are filing the if you are getting your EAD card in the month of March or something like that, so you're correct that till April they can file for the H1B. Then there will be 4 attempts. But if you are unable to get your card till the March, then you only have the 3 attempts. So is it true?
No.
Or,
No. They can apply for your H1 even if you don't have a card. That's not true. Okay.
Okay. Okay.
Good luck to you, sir.
Okay.
All right.
Yes, sir. And is it safe, sir, to go for the third party payroll? I mean,
for
just
OPT, generically speaking, yes. But again, discuss this matter with the employer's lawyers. They should be able to guide you. Generically speaking, it is possible in the first year of OPT, but not in the second and third year of OPT. Okay?
Okay, sir. Thank you so
You're
much.
welcome. Good luck. Guys, sorry, I've got to run. I told you that I'll be able to only answer this many questions. So we'll talk again in 2 weeks. We are back now. We'll be able to talk again in 2 weeks. Thank you all. I'll see you again. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.